Pretoria. The only trip that will take that is longer is to go to Bloemfontein. Now, when the respondent replies, he takes my Facebook page and he says, a cancel of the applicant travels a lot. Why can't he travel there? As if every trip I take is for fun. I'm not a legal tourist. I don't travel just the country for fun. I travel to do the work, being called by attorneys in areas. An attorney can call me in Middelburg, to consult in Middelburg and go to court in Middelburg. We don't have a situation whereby we can take a person who is waiting trial far from their lawyers, and we simply disregard an issue of right to legal representation and a right to consult with your legal representation, and equally so a right to a fair trial, because what they have done, it will impact on the fair trial of the applicant.
No, it's not.
It will, my lord.
You have the opportunity to consult. You must just make the necessary arrangements.
We didn't have an opportunity. That's why, my lord, we are on court on the 5th of February to say the consultation is not effective. We do it telephonically on a glass, whereby you have to write notes down. You can't write notes down, whereby you have to come with a laptop. You're not allowed to come in with a laptop or with any gadget. Now, my lord, there has been the 5th. The reason we mentioned the 5th was because that application speaks of the conditions that bars us, that makes it, that impede us as the legal practitioners to consult. We have been having a difficulty to consult. Now, when we have a difficulty to consult, they now make our situation to be worsened, taking him to Kokstad. Now, my lord, look at this. In their papers, when they send us a message, they say, we make security assessment. We are waiting for them in the replying papers, in the answering papers, to say, this is the security we did. Maybe Mr. Bester is busy trying to escape, as usually they say he escaped previously, all these things. But now they are not bringing anything. They just bring one annexure, I think, in their answering, which is NQEF4, which has only one paragraph that says he once escaped at Mangaung. Before they brought him to Pretoria, they knew that he escaped at Mangaung, as they alleges that. Now, we are having a situation of saying, what is the reason, procedurally and reasonable, on fairness, what is the reason they took him to eBongweni?
Security reasons, they've given that in the answering affidavits.
My lord, they've never given any reason. We have read them.
They have, you must just read the answering affidavits.
I read their papers. The only submission that they have brought is to say we have done security assessment. In that security assessment, then they claim to say, actually on our funding papers on page 001-41, they released a communique media statement on the 30th of January 2026. And on paragraph 2, they say, it has to be emphasized that offender transfers are on routine practice, guided by established security risk assessment to ensure the safety and security and stability of correctional facilities and the broader criminal justice system. Now, we are saying, we hear these reasons that you are bringing. Give us the established security risk assessment study or report that you have undertaken.
You haven't asked that.
We did on our papers. We did say, give us that. Now, instead of them giving us anything, on their answering, they give us annexure ENQ4, which is on 07-42. It's just one page here, written with a hand, to say an inmate also escaped. He also escaped, and then and also escaped the country unlawfully. All this, my lord, if there are allegations, before they took him to Kgosi Mampuru, they knew that. They knew those are allegations he's on a trial with. Now, the question you're asking is to say, what is the reason to take him to eBongweni Supermax? Because when you take him to eBongweni Supermax, you are also infringing on some of his rights.
What rights?
Rights to legal representation.
No, they're not infringing. They say that you must just make the necessary appointment before. They're not taking away that right.
They are, my lord. That's the reason I'm in this court.
No, they haven't taken away that right because they haven't refused you to consultate with him. They said that you must just make the necessary arrangements. They're not impeding on that right.
My lord, when we say you are impeding on the right, we are not just talking about a fact that says you can go and consult.
Yeah.
It's not a matter of just going and consult. Who will bear the cost of such consultation? Because, my lord, when we travel from Pretoria to Kokstad, we have to fuel the cars, or we have to fly to Durban and hire the cars to Kokstad. All these costs, they have to be filtered into that go and consult. Go and consult is not just a phrase. It has got cost attached to it. Now, when we say they are impeding on the rights of the applicant, we are talking about a simple fact that says we have a challenge here of saying our client will have to undertake the cost created unduly by the respondent. And the court has to look into that to say, this is unfair on our client. Why? Because our client has never budgeted to be taken to Kokstad. Even the lawyers were never informed when he was taken there, because we would have made the representation to say,
Listen, they need not inform you. If you look at what the regulations say, for security purposes, they don't have to inform you beforehand when they transfer to a Supermax or to another security. They don't have to inform you beforehand.
and my lord, I'm raising it before this court to say that security reason is just an excuse, because it has never been brought to say what is it that threatens security with the applicant, Mr. Thabo Bester.
You're not challenging that as unconstitutional.
My lord?
You're not challenging the correctional service regulations as unconstitutional.
I'm not challenging the regulation of correctional services as unconstitutional. I'm challenging one simple aspect here. When they say, as they communicated on the 30th of March, to say they did.
They couldn't do it on the 30th of March because it's not the 30th, it's only the 3rd of March today.
My lord, I'm saying on the 30th of March, they released a media statement. On the 30th of January.
Yeah.
Oh, not March, January.
Yeah.
It's only on the 30th of January, they released a statement that they did a established security risk assessment to transfer Mr. Thabo Bester to eBongweni, or the applicant rather. Now, the argument we are bringing is to say what entails that security study. Now, this security study, there is no report on it. There is no explanation for it. We have to now accept that they did that when they are only bringing annexure NQF on page 07-42, which has only one thing to say: comments. The applicant has once escaped. And now, the question I'm having is this: by the time they take him to Kgosi Mampuru, had he not allegedly escaped from Mangaung? Obviously, he had. Now, what has changed? Is there any new thing that says he is maybe attempting to escape again, allegedly? Nothing like that. Only the same old allegations that they are bringing, which are so dinosaur old. They are all known.
It's not that dinosaur old. The dinosaurs became extinct about 60,000 years ago.
It's an expression, man.
I know,
It's an expression.
I know, but it's not so old. It's rather fresh in the history. It was about 2 years ago when he escaped, and he was brought back from outside the borders of this country.
I'm not arguing the dinosaur, my lord. I'm saying they are just old. What they are saying, you see, what they are saying in their replying papers, it's so irrelevant.
That's not irrelevant. It's relevant that he's a sentenced inmate. He's sentenced for 25 years. He has a record of escaping. They had to go to international channels to bring him back, etc., and all these things. And now they say it's just for security reasons we transfer him to a Supermax prison. I'm asking you, what rights are they infringing of him? He has got the opportunity to consult, make arrangements, everything.
My lord, arrangements have been made.
Yeah.
Everything has been made. Now the question is that who will bear the cost of that, because he has no budget.
It's not the government's problem who will bear the cost.
My lord,
It's not them who's the reason for him to be taken there on security reasons.
my lord, whenever we talk about any organ of the state having to make the rights of an individual to be feasible or practical, we have to filter the costs into perspective, because it is section 39, subsection 2 of our constitution that says interpreting any legislation when developing the common law or customary law Every court, tribunal, forum must promote the spirit and purport the object of the Bill of Rights. Now, the correctional...
What section of the Bill of Rights are you omitting?
I'm talking about Section 39.
What section are you omitting? Are you leaving out?
I'm not leaving any section.
You do, because there's a section in the Bill of Rights which says these rights are not exclusive rights. It can be limited by laws and regulations of application. And this is what Correctional Service have done. They have their internal regulations on security, so they can limit the rights of him to be held at a specific prison or so. For security reasons, they transfer him, they gave that reason. What rights are they impeding on?
When we talk about limitation, it has to be justifiable. The reason I'm in court, I'm saying is not justifiable.
Why is it not justifiable to have him in?
That's exactly the reason that I'm trying to bring before this court.
I'm listening.
Thank you for listening, my lord.
Yeah, thank you.
Now, the reason we are saying his transfer is not justifiable limitation of his rights.
Why?
Is because he is taken far, and then his legal representative are far from him. There has to be a trial preparation that is underway, and that trial preparation include his rights to say he has a right to consult with his legal representative, which is Section 35, subsection 2B of the Constitution. Now,
Mr. Maila, nowhere on the papers has his right to consult been taken away, so they're not impeding on that right. For security purposes, you have to balance these rights. And they say, we've taken him there because for security purposes. And they say in their answering affidavit, just make the arrangements and come and consult with him. The fact that there are costs involved, that is not a factor to consider, because it's still in the interest of justice that he is kept in a security, in a maximum security.
My lord, on my heads of arguments, I do argue that when we talk about a right to administrative action that is lawful, reasonable, and procedurally fair.
What was unlawful here?
I will come to that. The right to administration action that is lawful, reasonable, and procedurally fair.
I'm asking what is unlawful?
I'm not talking about the unlawfulness only. I'm talking about the reasonableness.
Please. You are quoting from the Bill of Rights. You come there and say it's got to be lawful. I'm asking what is unlawful in what they did? Did they contravene any law in taking him there?
They have not contravened any law.
Okay, then it's not unlawful. Now the next one is?
Reasonableness.
Reasonable. What is unreasonable to have him in a maximum security because he's already shown that it's difficult to keep him inside? What is unreasonable to take him there?
The unreasonableness aspect of it is a fact that he is in a trial and he has to prepare for that trial. And then when they take him far from his legal representative, which he has a choice to choose the legal representative, they are now infringing on that right unreasonably so.
They're not infringing. They say, not saying he cannot consult. It's just a bit more difficult because of the circumstances. But they're not infringing on that right.
They are making it difficult.
Yeah, sure. But whose choice was that?
My lord, now that making it difficult, it does constitute, elementally it can be defined as working against his rights, as making difficult for him to exercise his rights.
They're not making it difficult. They just say, we're keeping you here because of security reasons, but your legal advisors are welcome to come. Just make an appointment with us. We'll give you the facilities. What is unfair about that?
What is unfair about that, my lord, is the fact that whenever they make that decision, knowing that he is in the middle of a trial
He's not in the middle of a trial. The trial is not even a trial that's set.
A trial, my lord, has got a preparation, has got pre-trial conferences. Yeah. It's still part of the trial. It's still part of the trial.
You've already dealt with that. Anything further?
I'm still proceeding. We have the preparations for that trial. We have the consultation to be done. When we go to court on the 18th of March, which is next week, we are expected to say, are you done with your consultation? When we went to court, as I said, I'm repeating that again. on the 5th was to say we are not able to consult. Let the court order that we be allowed a space to sit with him, be allowed to enter with the gadget and consult. Now, that is difficult. When we went to argue that for Kgosi Mampuru on the 5th, they moved him to eBongweni. That application became moot on its own. Now, he is at eBongweni. eBongweni, now we have to start afresh and request a more time to consult and even go to court again, that we be allowed to enter with the very same gadgets so that we can be able to effectively consult. Because the issue of consulting with a lawyer as per the Constitution, it is not just an issue of talking, it's an issue of being able to adequately do the consultation. Now, it has never been adequate.
Why
And
not?
even with this decision of moving him to eBongweni, it doesn't make it adequate consultation, which is the preparation for the trial that we are in.
Mr. Maila, the Correctional Service said you're welcome to come and consult. Just make an appointment. We will avail the necessary facilities to you. You just got to go there, make an appointment with them, go and consult. They're not infringing on your right to consult, but you want your butt on both sides of the bread. You want it everything. You want this court to exclude the security reasons why they moved him there.
My lord, there are no security reasons communicated. That's another point I brought forth, to say the only point where they had an opportunity to communicate the security reason is on annexure NEQ4 of theirs. That annexure says nothing. They just say he escaped. Now, we are asking to say, the main question they should have been answering is to say, when we assess this security at Kgosi Mampuru, this is the detailed security risk we found. We found that 1, 2, 3, 4, 5, 6 is happening, or this is happening. Now, nothing is happening. The only reason they transferred him is because they imagine, because there is nothing substantial that is submitted before this court. They imagine that he's a security risk. How so is he a security risk? Because all the reasons they are stating, my lord, those are the very reasons that made him to come to Kgosi Mampuru in the first place 3 years back.
Anything else?
Yes, there is something more, my lord. And now, procedurally fair aspect of this aspect.
Yeah.
Whenever somebody is being transferred, the practice is that he has got a legal representative. At least communicate with the legal representative to say, this is the direction we are taking. They have never, even in any simple terms, to communicate with the attorney on record.
Do they have to do that before they transfer him?
It's not they have to do it. It's one of the things that they have to grant an opportunity to say, this is where we are taking your client, which has never been communicated at all.
No, you haven't read the regulations. If it's done for security reasons, they don't have to advance reasons or give the opportunity in advance. It's clear from the regulation. Anything else?
My lord, which already we are arguing that there is no security reason because nothing of security has been communicated. It's just the word security that has been stated that we have security
reasons.
reasons.
You've said that now about 5 times. Anything else?
Proceeding on that, my lord, is to say now, when we are bringing this application before the court, is to make the court to see a simple fact of saying, at this current stage, his right to choose the legal representative that he wants on his matter, it has been challenged because we have
challenged. It's not challenged. They haven't said they may not appoint you.
the reason that he has been taken out of a possibility or even the space of us being able to consult, as ineffective that consultation has been. That also means that the legal representative on record have become now irrelevant to continue representing him.
No.
I will explain this, my lord.
No, you've tried that. Continue, please.
I'm continuing on that. I have explained to the court to say, when he was in Pretoria, there was ongoing trial preparation. As difficult as that it was, we have been trying to deal with some of the parts of consultations that we did. Now, at this stage, what more can we deal with when he is taken far? Reasonably speaking, my lord, it will not be possible for us to have any productive consultation. If we have to book to go to eBongweni, it will be for a day, for 2 days that we've been granted. Yeah. But it will not be as effective as it should be, looking at the amount of work that we have to put into this trial preparation that we are in the trial that we are in already, that we are in the pre-trial of it. So we are having a challenge to say there is so much that the first respondent, the National Commission of Correctional Services, including the second respondent, the Regional Commission of Correctional Services, have never looked into, and which this thing has to be considered to say when they moved him there, all these rights, they are somehow impaired upon, and which the court needs to be looking into. Now, this, my Lord, becomes the end of my address to the court, and just to say that the security risk assessment that they are claiming is there, we have not seen it. In their papers, it has not been brought forth. The reasons that the applicant has to remain here for trial preparation, that has never been considered. All the rights that we have already stated in our funding affidavit and the heads of arguments, they have not been considered. That becomes our case, my Lord, as the court pleases. I conclude on that note.
Mr. Madiba, seeing that we have about 8 minutes until lunchtime, will you finish before that? Do you want to
finish in 5 minutes.
5 minutes?
I'll give it to you in 5 minutes.
I'll give
There's
you.
no case here.
I'll give you 6 minutes.
Yeah, there's no case here, my lord. Mr. Maila should not go to trial. There's no infringement. No right has been infringed. Attorneys, counsel, legal practitioners travel all over the country. Mr. Maila himself concedes that he travels all over the country. All the department is saying, all the respondents are saying, and what the head of eBongweni says is that make an appointment. If they make an appointment today, they will see Bester, they will see the applicant very soon, even before the 18th of March, where the pre-trial is to take place. In fact, you know, Mr. Maila is a very interesting litigator. He argues points that are not even pleaded in the papers. If Lordship were to look at the papers, for example, you will see that the question of the 18th of March has not been pleaded in the founding affidavit.
Yeah.
You know, so it spends a lot of time on matters that are not pleaded. Does not make a case. When he's been asked, are rights in the Constitution absolute? He says, well, he doesn't give a clear answer. But the fact of the matter is, there's Section 36 of the Constitution. It is clear that the rights can be limited in terms of a law of general application. Now, the regulation to the Correctional Services Act, the Correctional Services Act itself, and the standard operating procedures, those are laws of general application. They apply to all the inmates, and they can be used. And there are cases, my Lord, that we have referred to in our heads that confirm that they can be used to limit rights of inmates or of persons. In fact, in this case, there is no violation at all of any constitutional right. And my Lord, I'm not going to spend a lot of time explaining that.
No.
They simply have to travel to, I don't know why Ms. Murero cannot travel to...
Mr. Bester is not the only one who is there at that facilities. Am I correct?
That's correct, my Lord. My Lord, we say in the papers that in recent times, there's an attorney from Pretoria in Sunnyside who traveled to Kokstad in eBongweni to see a client. There was also an attorney from Newcastle, which is a distance also far from Kokstad, who traveled there.
I suppose that's Newcastle in KwaZulu-Natal and not in Great Britain.
Yes, no, in KwaZulu-Natal.
Yeah.
You know, so there's an attorney who traveled from Pretoria, did that. They have to do that. The cost implications. In fact, Bester does not say that he's not prepared to pay his attorney. You look at the power of attorney, my Lord, and I must say that because he has given a power of attorney now, the point in Limina we're no longer proceeding with in Limina as the question of
That power
authority.
of attorney, which they next now, was signed on the 13th day of August 2025. That was long before this application, so it's
Yeah.
just a general a general power there.
It's just a general power of attorney, but I don't want to.
No, we're not going to fight
Yeah, I don't
that.
want to make noise about that. But on that power of attorney, Ms. Morero herself, it gives her the right. It entitles her to travel anywhere, to go anywhere in the Republic for Mr. Bester, to act for Mr. Bester. And then she sits here and she says, I cannot go to Kokstad because of financial implications, my lord. That submission is without merit. It's without substance, must be rejected for what it is, my lord. My lord, finally, if you look at their replying affidavit, you would see that the applicant has actually admitted that the transfer can be done for as long as, or it can be done in terms of Section 6(1)(b) of the Correctional Services Act, my lord. And I can refer you, my lord, to the specific portion of their replying affidavit. You'd find, my lord, that in case line 005/24.
Just one moment.
Where, 005, there's 24. In that paragraph of the replying affidavit, the applicant deals with the allegation we make in paragraph 59 to 64 of the answering affidavit. In that paragraph, we state that at 59, which you'll find, my lord, in the answering affidavit of the respondents at case line 075-65. We state that I must hasten to add that the transfer is lawful for one other reason. And then in paragraph 60, we then we quote Section 6(1)(b) of the Correctional Services Act. And then in paragraph 62, we then say, the warrant of committal that was issued against the applicant by the Western Cape High Court in 2012 remains extant. In other words, it's still alive. And it authorizes the National Commissioner to detain the applicant at any correctional center, including eBongweni. Now, by noting the contents of that paragraph, they are actually saying that they are not disputing that. So all these submissions that this is some unlawful conduct, it can't be, my lord. The applicant has admitted that the commissioner can and is entitled in terms of that section to do the transfer even to eBongweni, my lord. My lord, I don't want to repeat what you engaged with, your engagement with my learned colleague, but the security reasons we've outlined in the answering affidavit, my lord. It is clear that my learned colleague either did not read the answering affidavit or simply does not want to tell this court that the security reasons have been outlined. Now, if it is for security reasons, my lord, as you had correctly pointed out, the applicant did not be informed at the center of origin, that is in CMAX, but must be informed at the center where it's been transferred to in eBongweni. And that was done. Mr. Ndachana confirms who's the head of eBongweni Center, confirms that in his confirmatory affidavit. So, my lord, all in all, there are a lot of submissions that I want to make. But I in the interest of time, I mean, there's no case here, my lord. There's also the submission that I would have wanted to make as to the question of separation of powers. management of prisoners and transfer of prisoners is the preserve, my lord, is the preserve of correctional services. Now, any court order that would want to interfere with that would breach that principle, my lord. But I don't want to waste a lot of time on that, my lord. This application is one that falls to be dismissed on the merits, because the decision was lawful. There's no infringement of any rights. The applicant's legal representatives have consulted with the applicant, can still be able to consult with the applicant. And if I may add, if Mr. Bester is no longer happy with them or doesn't want to pay the cost of traveling, he has the right to choose his legal representatives. He can substitute them if he wants to. So there's no issue. In fact, Mr. Maila himself, when he was being questioned by this court as to whether there's been any law that has been contravened by the respondents, his answer was an emphatic no, my lord. Why should this matter detain this urgent court further? This matter must be struck off on the basis of lack of agency, or it must be dismissed completely, my lord, on the merits. Those would be my submissions, my lord. My lord, in the limited time that was given to me yesterday when I received the replying affidavit, I tried to do heads of argument, and I prepared the heads of argument, but I saw there was a lot of typos which I've been clearing as I was sitting here. My instructing attorney will upload my heads of argument on the case lines after this hearing, as the court pleases.
Thank you. Court will adjourn until after lunch. See those gentlemen up back there. The matter continues after the adjournment for lunch. Mr. Mahila, you want to reply?
As the court pleases, yes, my lord, I have a very short reply. It's not going to be long.
That's
Number
fine.
one, my learned colleague says I'm addressing things that are not on paper. Everything that I've been addressing the court on is on paper. It is in our funding affidavit. It is in our heads of arguments. It is in our replying that we gave them. The only a challenge that we are having, which they have not yet even addressed to now, is what they call security risk assessment. Perhaps by asking that, we are asking too much from the first respondent to say, you have transferred him for security risk assessment that you say you have done, which it has not been handed to us. Maybe that is too much we are asking, but at least there should have been a communication to say these are the basis of the security reasons that the reasons or the things that we have observed. None whatsoever has been given. Number two, my lord, I'm glad that you do acknowledge that when our client is moved to eBongweni, it becomes difficult. Now, filtering into that difficulty that we spoke about, we still are saying that difficulty, it also has got our case remains to say it has got the constitutional rights impediment. Why are we saying there is a constitutional rights that are impeded upon? Because, my lord, we cannot just say if it's difficult, it involves the finances, therefore go there. My lord, the interest of justice has to look into the finances of the applicant in this matter. In the other trial, him being the accused. We cannot stripple person financially and say, it's fine, you'll be able to consult because nobody's stopping you. That has to be looked into, my lord. And we also have to, from what my learned colleague has addressed, to say we are talking about the 18th, which we never addressed. We never mentioned the 18th. We talked about a trial. We talked about the trial preparation. We spoke about the pending trial that should be happening in Bloemfontein. We never raised the specific dates. Why we never raised the specific dates? Because we know that the 18th is still a case management as per what we are dealing with in Bloemfontein. But that has been marked as saying it is the last one. Despite what happens, this is the last one. We have to set the matter down. When we come to court, you must be ready for trial. And to tell you the truth, my lord, we have not been ready for trial. And by look of things, we will never be ready for trial anytime soon because of the difficult situation that has been created. And my lord, the clarity that I will want to bring before this court is this. We are not saying the decision of the first respondent to the sixth respondent is unlawful. They are acting within the ambit of the law. They are empowering legislations. We are saying it's unreasonable and to a latter degree unprocedural. That is where our argument finds its root at. The unreasonableness is the difficulty that the court has acknowledged that yes, it might be difficult. We say that difficulty, it has been created under unreasonable pretext of the situation because there was no necessity for him to be transferred there under the security assessment that has not been communicated to this court. That has never been stated on the papers. Only the wording of saying security reasons. Now, these security reasons have not been brought forth so that we can say, yes, this makes sense. Now, since these security reasons have never been brought forth, it becomes so much unreasonable to say the applicant must be taken to eBongweni. After to be taken to eBongweni, then he needs to fund that trip. As you have suggested, my lord, to say you need to do a pro bono at one stage. Pro bono we do, but you will not want to do a pro bono of a traveling cost. You'll want to do a pro bono of court work, which is when I'm representing a client in the court that I'm able to consult with him without any harsh difficulties, which have been created at this stage. My lord, the court needs to look at this issue from this angle. Traveling from Pretoria to Kokstad, and then at one stage we have to travel from Pretoria to Bloemfontein. All these trips have to be paid for by the very same applicant who have been transferred under what has not been reasonably communicated to the court, only to say we have a power to. Having the power to transfer him needs to be guided by reasonableness, needs to be guided by procedural fairness, which is constitutionally clear. On our heads of argument, we do speak about the procedural fairness to say, in the context of this matter, there has been a challenge with the procedural fairness. That procedural fairness needs to be looked into by the court to say, when they are transferring the applicant during the trial, which is under preparation, is it procedurally fair? Definitely it has not been procedurally fair, because there has to be consultations that are happening. And they said, my learned colleague says, if ever the applicant, Mr. Thabo Bester, is not able to consult, he can change. Now, it is now the system that is forcing him to change the legal representative. He did not want to change. He was happy with the legal representative. He was happy with Advocate Mwafrika Maila as his counsel. He wanted to keep him. Now that he's failing to consult, his right to choose a legal representative has been infringed or impaired upon. He now has to choose a counsel in Kokstad who will be able to consult with him further. And at the time when he has succeeded consulting, we don't know. I'm not a prophet neither. He might be transferred somewhere else. Then will he get another counsel somewhere else? That's where now the challenge comes in to say, there is a counsel he chose, there is legal representative he chose, such legal representative that he chose need to proceed with the matter, and they are put under a difficult situation which is unreasonable for that. That's why now, my Lord, on our heads of argument, we do bring a question of, Section 6 of Paja Act. We bring Section 6, subsection 2 of Paja Act to say when the administration was biased or unreasonably suspected of bias, B, a mandatory material procedure condition prescribed by an empowering provision was not complied with, the action was procedurally unfair. C, the action was materially influenced by error of law. Now, my Lord, here we are speaking about unreasonably suspected of bias.
Can I just interlude here? What you're now bringing is a total new line of argument. You never argued anything on Paja when you had the opportunity. It's not in your papers. Mr. Matiba did not address that, and now in reply you come and you want to have a second bite at the proverbial cherry. That's not allowed. Just stick to what you're supposed to do.
Yes,
in the
my
reply.
Lord, I will stick. But necessarily, we spoke about Section 33 of the Constitution, which speaks about the procedural fairness. Now, that Section 33 of the Constitution is being now expanded on Paja, which is Section 6, subsection 2. It's just I'm reading this, which I've never done before, but necessarily is the same line of reasoning. I will move from that reasoning line. Now, my Lord, when we speak about procedural fairness, we speak about a suspected bias. When we reason on our agency, which is on my papers, we speak about the case, we speak about a case of Mogala Kwena, where they speak about prejudice, to say once prejudice is being found, the court needs to look into that matter. When the rights are prejudiced, the court needs to look into that issue attentively so. Now, my Lord, a fact that we are not saying straight to say we are not saying straight to say for the transfer of Mr. Thabo Bester to eBongweni, it is wrong in this and that aspect. We are putting the rights, which are also those rights protect us as the legal representative, is what the court needs to look into. To say, are these rights of the applicant that's supposed to be protected in this application as we are bringing them forth? Because the whole arguments and the application that we are bringing before the court is to say, my Lord, we have been put in a position whereby we cannot be able to do our work. And some of the reasons that have been brought to say the counsel of the applicant travels, whereby they even took some of the stuff as annexures of my social media pages, it's not a valid reason to say just travel because you travel. I raised that. it has to be understood. Every trip taken by a legal practitioner, it has got the cost implication. And my lord, if we don't look at this cost implication, we will be failing the applicant, because the applicant cannot be exhausted financially. By the time he gets to a trial, he is not able to pay the private defense that he chooses to use, which now include the choice of legal representative. I'm trying to bring an argument to say we should not position the applicant in a difficult situation whereby he will spend money in a preparation of a trial, so that when he goes to a trial, he finds himself whereby he's already financially exhausted, which is likely to happen in this regard. Looking at the distance, looking at the distance, the required resources for such consultation. And my lord, this whole thing that they're writing on their reply papers, on their answering papers, which you put in our answering papers to say he can do online. Since Mr. Thabo Bester went there, we do address it. He has not been even able to phone the instructing attorney. He has not been able, he only phoned once to say, are you aware of eBongweni? Then that was it. They talked only that, kindly do something with it, because I will not be able to.
Can I then, sorry to interrupt you here, and what you're saying is that there was no consultation with Mr. Bester since he was taken down to eBongweni there in Kokstad?
There has never been a constructive consultation to say...
A consultation with him?
Yes, there's never been a consultation whereby we sit down with him, we consult.
While he's there?
Yeah, while he's there.
Then it raises the eyebrow that the documents, the affidavit and everything before me at this stage, was it then drafted after or before? No, let me finish. Because if there was no consultation with him after he was transferred, no consultation at all, as you say, then how can there can be papers on his behalf if he was not consulted constructively?
As it's stated on our papers, it was through a phone call that was given at a very brief chance to say, he requested, let me call my legal representative, inform them that I am at eBongweni Supermax, and then I want to give them the instruction. The instruction was to say, kindly file on my behalf for my transfer, because I will not be able to finance a consultation to this site, and then the likelihood is that whatever that we've been fighting for, an adequate facility to consult, which was the case of the 5th of February, it is now moot. I need to go back to Pretoria so that we can be able to properly and effectively consult. As per the Constitution, as per the rights enshrined in the Constitution. So now, that's why, if you look, my lord, the funding affidavit was never deposed by Mr. Thabo Bester. It was deposed by Inolofatse and Courage Morero, who is the attorney. And then he only relied on the power of attorney to say, I've got the power to take this action because I've been instructed. Why now agency has already been addressed? Simply because there is a trial preparation that is underway. So, my lord, the whole situation, it needs to be understood from a basic angle of distance, costs, and rights. That's what informs our application.
Yeah. Anything else?
Anything else, my lord, is that the applicant has made up his case, that the court ordered that he be transferred back to Kgosi Mampuru so that he can be able to continue with the trial preparation. And then once he's done with the trial preparation, then the first or second respondent can choose what they do with him because it's in their custody. They can take him back there or whatever they want to do with him. But for a period and a space of trial preparation, he needs to be brought this side. And my lord, last point, when he was supposed, because on the 5th of February, he was self-represented. Before he was moved from Kgosi Mampuru, there was an arrangement to say he will be taken to Bloemfontein, where he will be presenting his case in person. When they took him to eBongweni, instead of taking him there to Bloemfontein from Kokstad, eBongweni to say, they said we have no resources or finances to do so. Now, it shows also to say the very same state that took him there cannot afford to transport him, which is there on the papers. They cannot afford to transport him, but they expect us who are private to be able to manage all this cumbersome trip.
Yeah.
Our case is simple. It has no any complication. It simply says he chose his legal reps. Those legal reps that he chose are based in Pretoria because he was based in Pretoria, and he was in the middle of trial preparation, whereby he was consulting with legal reps, and he needs to continue with the consultation with the legal reps, and he's therefore requesting that he be brought back. Because even his transfer, it has never considered such circumstances. Now, without considering such circumstances, that becomes unprocedural, that becomes unfair, that becomes unreasonable. Though lawful.
What is unprocedural?
What is unprocedural is the fact that you take a detainee who is in the middle of a preparation of a trial, knowingly.
No, he's not in the middle of a preparation of a trial.
Preparation of a trial. We are consulting, that's a preparation.
Yeah.
We are preparing for a trial, my lord, in Bloemfontein. We even have inserted the case number in our papers.
I've seen that.
That has never been considered. That becomes unprocedural to say, if at least they should have considered that, they would have not transferred him now. And even they transferred him so timelessly to see that the first respondent has got his own agenda on this issue. What agenda, we don't know. Because they transfer him by the time he's arguing the conditions at Kgosi Mampuru. Why do they do that? The application was moot already. They are already rendering the court processes to be unnecessary, and then somehow they undermine the processes of the law. Because they're supposed to wait the court to make an order about Kgosi Mampuru. But they never did so.
Yeah. Anything else?
My lord, that is that. We have made up our case in that, and as the court pleases, I conclude that becomes my submission.
Thank you. I just want to have a look at one thing here, which the court is referring to the matter number 8 on the urgent court roll for this week. It's the matter of Thabo Bester versus the National Commissioner of Correctional Services and 5 others. Case number 2026-021077. This matter is before this court on the 3rd of March 2026 in the urgent court. On the notice of motion, and I refer to the case lines pocket 001, notice of motion, and I quote, be pleased to take notice that the applicant intends making application before this honourable court on an urgent basis on the 10th day of February 2026 at 10:00 hours or soon thereafter. That is the only notice of motion on the electronic case before this court. It is tried that on the 10th of February 2026 there was indeed an urgent application in this court before my sister Kgosi, and she heard the matter and she struck it off the roll on the 10th, and I quote from paragraph 15, I am thus not persuaded that this matter is so urgent that anything more drastic than enrollment on the motion court in the ordinary course on short notice is required. This matter is struck off the roll because it was not properly enrolled, and the applicant is at liberty to enroll it properly if he wishes so for the next urgent court. Now, what is important to note, the applicant, without changing, making any amendments to his notice of motion, just have a date, or obtained a date from the registrar and re-enrolled the unamended notice of motion. So actually there's nothing but before this court but an notice of set down. But that does not cure the non-amendment of the date on the notice of motion. It does not cure at all the problems which the applicant encountered in that court with regard to the extra short time notice given as to deviate from Rule 612B. The applicants were there requesting the respondent to notify the applicant's attorney not more than 1 day after receipt of this notice whether they oppose, and then also within 1 day to file any answering affidavit. That is what's before this court. It is a notice of motion, unamended. The problem with such sloppy work is that, and after hearing Mr. Mahila on behalf of the applicant, I decided to hear the matter. In reality, in strict compliance with the rules, I could have struck this matter because it wasn't properly enrolled. But be that as it may, the next question then to answer is the urgency of the matter. The applicant avers in the founding, or on his behalf is averred in the founding affidavit by his attorney of record, that there is a civil matter which is on the 5th of February 2026 in Bloemfontein. Now that's water under the bridge. It was even water under the bridge on the previous occasion in court on the 10th of February 2026. So that is not an argument. The civil matter where he, Mr. Bester, appeared in person. The second ground which they aver on this long argument on biasness, suspected biasness, procedural unfairness, is that he's in the midst of another trial, a criminal trial, in the Bloemfontein High Court. That's not true. He's not in the midst of a trial. There's not even yet a trial date set down. The closest to a set down of trial in the criminal matter, and I assume it is for him, the charges against him and his co-accused for escaping from the Mangaung prison where he was held after being convicted on another matter. It seems like the earliest date that criminal trial will proceed in the Bloemfontein High Court is probably in the third term of this year. The third term only starts on the 20th of July of this year. There is a suggestion of a pre-trial which is to be conducted on the 18th of March 2026 in the Bloemfontein High Court, preceding the criminal matter which still has to be enrolled. There is no reason why, such as the appearance of the appellant in person on the 5th of February 2026 in civil matter, that he cannot use the same facilities there where he is, in eBongweni, in Kokstad, to consult with his attorney and counsel if they don't want to travel down there virtually to prepare for the pre-trial. There's no reason advanced. It may be more convenient for him to be in the Gauteng area, whether it is at Kgosi Mampuru 2 or even at Leeuwkop, as was suggested in some of the papers before the court. But there's nothing untoward about his transfer by correctional services from Kgosi Mampuru to Kokstad. He was transferred there for security purposes. The correctional services regulations provide for such a transfer, and he need not be informed beforehand that he is that there's a decision to transfer him away from Kgosi Mampuru, and that he can make representations. So there's nothing procedurally wrong, unlawful, unfair which has taken place. His right of choice of a legal representative is also not infringed. They can consult with him there. They can make the necessary arrangement to consult with him virtually. It happens in the 21st century that many consultations are done virtually. So there's no reason why it cannot be done, keeping in mind that the reason why he was transferred there is because of security purposes, because he has a record for escaping from a maximum security prison in Mangaung. He's now in a supermax where hopefully there are better guiding facilities and better taking care of the inmates there. I don't see any urgency in the matter, but on the merits, I also see no merits why he should be transferred back. Under the circumstances, the application by the appellant to be returned to Kgosi Mampuru, or, as suggested in some of the other papers, to Leeuwkop, is dismissed. With regard to the costs, I have listened to the parties. Although it's not a constitutional issue as such, although there were references to the right of a fair trial, the right of the choice of your representative, I am of the view that it would be fair that in this instance each party pay their own costs. I therefore make the following order. The application for retransfer is dismissed. Each party should pay their own costs.
As the court pleases.
That concludes our roll for today. Just for tomorrow, there's another matter enrolled. It's matter number 20, Mamokebe Investments. The parties, the matter was set down for tomorrow, but because there is another matter in the insolvency court, they have consolidated it with the consent of Acting Justice Sullivan, who was presiding there. I have a draft order that this matter and the winding up matter is consolidated, and the parties, this matter is postponed until the 17th of March 2026, where the matter will be heard under the consolidated number, and there is sufficient provision for the parties to file papers to amplify the existing papers. So it is just removed from the, it's postponed until the 17th of March for the records. The court will adjourn.